I think most everybody's on. It looks like we have a few more probably still coming in, but we'll go ahead and get started. We're going to, just a reminder that we're going to stay on mute just so we don't get all the background noise and we can hear Mike clearly. And Mike will take questions as they as they come up. If you could use the chat feature there on your screen to type your question, he'll follow that along and address those as we go. That would be the ideal. So, Gian, if you want to take over, then you can start the meeting.
Okay. I'd like to welcome all of the seniors to another Zoom meeting, and hopefully we're getting pretty good at Zoom, hopefully. I would like to, we will start the meeting with a prayer, but I just would like to say, you know, in this time of unrest, don't forget to go outside and see just how beautiful these days are. They're a gift from God. Look at the leaves and they're changing color. Look at the sky, how crisp and blue it is. And the sunsets have just been stunning. So there's still beauty around, a lot of beauty. And this is a beautiful time of year. So I have a very short reading, and then we'll say the Lord's Prayer together. And then I'll introduce Mike and we'll get started with the meeting. This is called the Prayer for Contentment. God of abundance, you provide for me as you do for the birds and the lilies. And yet, while I know worrying will not add a single moment to my lifespan, I still struggle with anxiety about things that are not in my control. Help me to take the next step. Help relieve me of worry over what comes after that. For I know in faith that you will provide what I truly need. Amen. Our Father, who art in heaven, hallowed be thy name. Thy kingdom come, thy will be done on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses as we forgive those who trespass against us. Lead us not into temptation, deliver us from evil. Amen. So without further ado, Mike, we remember Mike Williams from last year, those of us that were in the meeting, and he promised to come back and give a class called the Life Class. And hopefully all of you who are here have received the book. We tried to get them out to everybody. So that's what he'll be using. And as we go along, I'll let him explain how he wants to take questions and kind of stuff. So Mike, are you ready?
Yes, okay. I'm ready. Okay. There you go. You start the slideshow would be acceptable. Everybody knows who the Ventura County Area Agency on Aging is. You can flip slides, please. There, keep going. There you go. That's me. We've been around since 1979, providing free legal services to seniors in Ventura County. We are a very low budget organization based on volunteers. And this has been a particularly complicated time because most of our stuff has been done face-to-face. And now we're a telephone hotline. I do see people occasionally face-to-face, but that's an exception anymore because mostly we're just talking on the phone, which is a little bit more complicated. It's complicated to look at documents or anything that might be necessary like that. So, but we're still trying to keep the program rolling. Next slide, please. Okay, Life Class, legal information for elders. That's what it's all about. Next slide, please. Okay, you can go ahead and click down all of these. There you go. in the front of the book, there's this guide. And I need you to understand that stop does not necessarily mean stop. It means you probably need somebody to help you, like a notary, where you cannot do the thing automatically. Caution is more of a stop than stop under the circumstances, because caution is saying, wait a minute, there's some danger involved here. Okay, next slide, please. We're going to be trying to do this as nicely as possible, but you guys are going to have questions. That's normal, that's the routine. If you ask questions in chat, and if I can see them, I will, if they're on point, I will attempt to include them in the presentation, but not stories. So if it starts with, I know a guy who, that's not a question, that's a story. Let's leave those for another time, because what I would really, really like to do is to be able to get through as much of this as possible without boring you guys to tears. And there's a lot of information. So let's try to keep it on. Okay, next. Next slide, please. Oh. Okay. On page 11 of the book, there is a quiz. And I usually tell people about it before the class, but it didn't sort of pan out like this. And the quiz is not intended to tell you whether or not this class is going to be important or interesting at all to you. It's just information that this is sort of the topic areas that we're going to be covering, because I have a lot of people who have questions, who have a living trust as an example, but they don't even know how it works. And so it becomes, when I start explaining, when we get to that topic, for example, people will start to see it from a different light, because it's not rocket science. And some people think it is because they've got this book that's 3/4 of an inch thick and they really don't want to take a look at it. But that's just an example. On page 12 is the list of important papers. And one of my favorite lines here is, this is not something that you want to use a magnet and put on the front of your refrigerator, because this is going to be information that would be very, very useful to somebody who's trying to steal your identity. But if something happens to you, this information is probably going to be very important to whoever's trying to step in and take care of you or your children, okay? So it is a good idea, but it's not something that you want held publicly. If you have a living trust or will or important papers, this is something that you should probably consider keeping with that. Next slide, please. Okay, thank you. The caregiver authorization affidavit is how many grandparents? And I'm not going to be able to see raised hands, but I'm a grandparent, and I have the ability to go down to my grandkids' schools and get them out of school to take them to the doctor or take them home if they're sick or whatever, because there's a book or a computer entry at the school that allows me to do that because my name is on a list. Well, that's basically what the caregiver authorization affidavit is. My wife and I travel, and we like taking one of our grandkids along with us, especially if they've gotten good grades and we can provide them a fun trip. Then what we do is we have the mommy and daddy prepare a caregiver's authorization affidavit, and we take that to the border or the airplane. So they can see that we're authorized to be, even though we're not the parents. Now, decades ago, how many people here remember, and I'm asking the questions and you can't even hardly show me your hands, remember Leave It to Beaver? Because the Cleavers, Mrs. Cleaver was a housewife, which is practically a lost skill anymore, because her husband worked, that was enough money for them to pay for the house, and get the family by. And that simply doesn't exist anymore. Both spouses, both parents have to work to keep the household going. And so it's Mrs. Cleaver is not available in every house to make those trips to the school because somebody lost a book, or do all those other things that are sometimes necessary when you have children. And this simply allows family members to fill in on behalf of the parents. Okay, now that's a relationship, and that's called the Caregiver Authorization Affidavit. That makes it legal to do that. And the question is it absolutely necessary? And it sort of depends on who you talk to. Now, the next level, because in the law, you think about, my sleeve disappeared. There it goes. That was pretty cool. There's a line, and everything in the law is basically linear. And when I say linear, I mean way over here is Mrs. Cleaver. And then at the far end of this spectrum, the far end of this linear line, is what I refer to as the train wreck families. And that's sort of self-explanatory, not necessarily perfectly explanatory, but the train wrecks, okay? And Mrs. Cleaver does not need even an caregiver authorization affidavit. But most people today probably will need some assistance, cousins, grandparents, whatever, to help out periodically when both the parents are working. Well, the next step down that spectrum is called the probate guardianship. Probate guardianship is very similar to a probate conservatorship, except a probate guardianship means that the person who is having the guardianship placed on them is under age 18. So conservatorship, if you're 18 or over, then it would be called the conservatorship, okay? There are two elements to the probate guardianship. One is of the person, and the other is of the estate. And of the person means you can tell them where to live, you can tell them what school they're going to go to, you can tell them what doctor to go see. Of the estate means if they have any money, then you're in charge of their money until they're age 18 and the conservatorship ends, or the guardianship, my apologies, okay? And the difference between the authorization affidavit and the probate guardianship is that a court is intervening, and things are done, although the parents are consulted, the things are done under the consent of a judge of the Superior Court. So that's a significant transition from parental control to court control. And then the next down the line, adoptions, is the next logical step. And I refer to that as the train wreck families, where the parents are deceased, or the young mother can't take care of the child. And there's a million other possible alternatives where under those circumstances, historically, the rights of the parent are gone. So the parent is no longer involved. In fact, until recently, you could not find out who the natural blood parent was through the court system. It's changing, it's flexing now. It's not the same simple thing. But you see how it's linear. And this is going to come up a couple of times today, where things operate in the linear, where the law has to take care of pretty much everybody, but they're not going to do it in the same exact way. And this is a good example. Now, Gray law does not do grandparents' rights. But when this book was originally drafted, it was something that we thought was important. And so it's in here. But if you have a question about family law, grandparents' rights, I'm probably not the right guy to talk to. Most of the rest of this book I have dealt with. Next slide, please. Elders at risk. Okay, fair question now. If I'm in a restaurant about 15 years ago, and this guy who was actually my age now was yelling at a woman at the table next to him. Now, do you guys consider that to be elder abuse? And the reality is it genuinely depends on what he's saying. If he's saying, do you want French fries with that? Then it's probably not elder abuse. But even if he's saying, which this guy was, you're a horrible mother, that doesn't necessarily mean that's something you're going to be able to call the police for, okay? But if you find something and you're not sure, then it's appropriate to call Adult Protective Services. And in the back of the book, section 10, since I don't have one of the books here, I'm going to have to sort of remember stuff. But in the back of the book, section 10 is some forms, and section 9 is addresses and phone numbers, including ours, including Adult Protective Services, and a bunch of other services throughout Ventura County. Section 9 is very useful. Now, if you look over on the side here where it says how to report suspected elder abuse, page 34, in the book, if you want to follow along, at page 34, for the most part, is relatively accurate. That's where you're going to find this topic, okay? Now, reporting elder abuse in a care facility. Again, I'm going to ask for a raise of hands. How many people have heard of the long-term care ombudsman program? Because that's the people that up until COVID-19 were in the senior centers, were in the care facilities that actually talking to people and looking around and seeing what abuses there might be. But before the long-term care ombudsman, just for Ventura County, there would be a book an inch thick every month on violations at all of our care facilities. And it was amazing. And the long-term care ombudsman came in. Most of these problems do not exist anymore. The bed sores and left in urine overnight and things like that. They simply don't exist anymore in Ventura County because of this wonderful program. But if a person in a skilled nursing facility asks or mentions to a long-term care ombudsman person that there's some kind of a violation or some kind of a problem or they've been treated poorly, that's not reporting it, because the long-term care ombudsman, like an attorney, cannot disclose that information unless they are specifically given permission by the person telling them to do it. For attorneys, it's called attorney-client privilege. It's not my privilege. It's the person disclosing the information to me. So if I have somebody walk in and say, I think my son just stole $40,000, I can say, you need to call Adult Protective Services and you need to call the police department. But I can't do it for them unless they specifically give me permission to do it. And the reality is most mommies do not want their children to go to prison. So a lot of that stuff does not get reported, and that's unfortunate. Next slide, please. Okay, elder abuse restraining orders. One of those things where I talk to people and say that this is the greatest thing since sliced bread. There's a couple of areas on this program that I say that. The elder abuse restraining order is one of those tools that allows you to deal with an imminent problem in a way that you can't deal with otherwise, okay? Now, let me give you my classic example. To me, a lot of seniors are trying to supplement their income by bringing in a tenant into their own home. And that works and it doesn't work. I mean, it really depends on the circumstances of the two individuals or multiple individuals. But if there is some abuse, the way that the traditional way of getting that person out of the house, if they've been there for more than 12 months, is a 60-day notice. So they've got 60 additional days to abuse the senior. Well, wait a minute, at the end of the 60 days, what happens? And the answer is if they haven't left, then you have to serve an unlawful detainer on them. Okay, that's the law. And if they respond to the unlawful detainer, we just wasted 2 more weeks. But once they've responded to the unlawful detainer, then you would go in and set a court date, which would be somewhere between 4 and 8 weeks out, which means that we have just blown through 4 months at least without alleviating the problem. So the elder abuse restraining order, and there's an office at the district attorney's office, the Victims and Witness Assistance Program with the district attorney's office, who will fill the form in for you for free. And you can have the person out of your house the following Wednesday when these things are all heard on senior day in that particular courtroom. So if it goes over there on a Monday, 2 days later, they're gone. So to me, that's the greatest thing since sliced bread. I mean, that's a magnificent result. It's so much better than potentially 4 months of additional abuse. Now, the Dementia Checklist. Okay, honest, I am 70 years old, and yesterday I walked to the refrigerator, opened the refrigerator door, stared at virtually everything in there, closed the refrigerator door, turned around and thought, what was I doing? But that doesn't mean I have dementia. That means that I'm a senior. That's what that means. Now, having said that, my dad didn't lose his sense of humor until he was 96 years old. I think that's amazing. As long as I have my sense of humor, I'm good, right? I believe that. But historically, human brains are not intended to last 96 years. And so they start to deteriorate at some point in time. And people have said as early as mid-20s, they start to deteriorate, which I'm not buying that. That was a young person that thought that one up. But at some point in time, they definitely start to deteriorate, and that's totally normal. That's not severe dementia. That's not Alzheimer's. Those are 2 separate and distinct things. And so the good news is, or at least that I use it as good news, is I have been told that as long as you are concerned that you might have Alzheimer's, you don't have it. As soon as you stop being concerned about whether or not you have Alzheimer's, well, then you may have it. Okay. Now, so understand that that's where we get into the conversation about the conservatorships, because most people do not need a conservatorship. In fact, most people feel bad when rights and privileges are taken away from them. Like, for example, my dad was 86 when the doctor said, my sister went to the doctor with him, and my sister said, should my dad be driving? And the doctor went, he's still driving, which was probably not a good sign for him, but that was the explanation. And it's funny now, but it probably wasn't very funny to my dad, because what they had effectively done was taken away something that was important to him. And one of the things that people don't understand, if you turn your checkbook over to one of your kids so they can take care of the bills too, you have just lost some control of your life. And that's something that should be very closely guarded, and is mostly very closely guarded by people. A conservatorship is the modern way to take authority away from somebody. The first conservatorship that I did was in the early 80s. And it was for a guy who was actually younger than what I am now, but he was a diabetic, and he had one leg amputated, and he was in the process of having his other leg amputated. And so he didn't like to get out of bed, and he smoked like a chimney, and he had set his bed on fire twice in the previous 30 days. And his son, who was totally freaked out, came in and said, Mike, I need you to help me. We got to do something here. This is just simply not working out. He won't take care of himself. He takes his insulin with dirty needles. He needs somebody to run his life for him. So we filed a conservatorship. We went in front of Judge Willard and the probate court back when they used to call him back into chambers. And so we had his wheelchair and the son pushed him into chambers, and I went in with him, and Judge Willard listened to what we were saying. And at the end of the conversation, when we were talking about all the horrible things that the family had to deal with, and the son explained that, look, I wake up at 2 o'clock in the morning practically screaming because I envision smoke coming down and my kids suffocating to death. And we can't do this. And Judge Willard looked at the gentleman and said, sir, do you understand what a conservatorship is? And he shook his head, yes. He says, do you want this conservatorship over you? And he said, no. And Judge Willard dropped his gavel and kicked us out of the office. No conservatorship. Because what a conservatorship is removing constitutionally protected rights. So it's taken very seriously. All of the old movies where the woman is in the mental institution and saying, well, my husband wanted me out of the way or whatever, that may be good for theater, but it's just not accurate, okay? Because it's the constitutionally protected rights in this country. The foundation of our nation is individual liberty. And it's something that we hold very sacred. Conservatorship, like the guardianship, has two elements. Element number one is of the person, and element number two is of the estate. And I have seen families, I've been involved in families where, in fact, the first time they ever pressed the panic button in a courtroom where I was in a conservatorship hearing where the family went into fisticuffs over grandpa's extensive assets out in the valley. And so under those circumstances, a conservatorship was absolutely magnificent. It was wonderful. It created peace in that family because there was nothing they could do about it. And the person who's in charge of the money has to provide an annual accounting to the court. So the reality is a conservatorship is a true pain in the butt. But under certain circumstances, it's perfect answer. Now, having said that, one of the things that we're going to try to do today is explain to you how you can do away with the need for a conservatorship over you, okay? Because you don't absolutely have to have a conservatorship. Conservatorship is generally a result of not planning. So this is on you individually to come up with a way of saying, I don't need a conservatorship because I'm going to plan it. I'm going to set the world up so if something happens to me mentally, then somebody can step in who I choose and take care of me, and take care of my finances. Was there a question there? No, no problem. Okay, next slide, please. Okay, now missed the whole slide. Now, truth, it's not important. This is fine. There was a slide in there that talked about taking care when you sign something, to read stuff. And the whole spiel about being careful when you sign something, there's shades to that also. Because, for example, if you go down to buy a car, the Uniform California Automobile Sales Contract is the most litigated, most legislated document probably in the universe, okay? So, and I question you this, if you wanted to buy a car and wanted to change one word in that agreement, do you think you would still get the car? And the answer is no, because you can't change that form. So it's not something that you it's mandatory that you read, especially if you have previously read it, because it hasn't changed much. But if you're having a plumber come into your house, and I have friends who are plumbers, but I'm saying in general, if you have a plumber come to your house and he hands you a contract for whatever work it is that you want done, the legislature has never seen that contract. That contract was prepared probably by his attorney for his benefit, not yours. So please read it. One of the complaints that we don't get as often as we used to is, and we used to get these things, oh, I'd say once every 2 weeks, year in and year out, was either for DirecTV or Dish Network. Because once you're into that contract, in that contract it says, if you terminate this within 24 months, you still owe us the money for the full 24 months. And most people don't even look. They don't read the contract. And if they had read the contract, they would know. And there are a multitude of contracts very, very similar to that. So you can't just escape and sign everything. You have to take the time and read it. And that's one of the reasons that salesmen will hold you up as long as possible until they're absolutely convinced you're bored to death and then hand you the contract. And that's just called sales tactics, and you cannot allow that to happen. And nothing upsets a salesman more than after 15 minutes, you're still reading his contract and asking him questions. So sometimes I do it just for revenge, but that's okay. I'm teasing. Next, this slide, advanced healthcare directives. Now, what is a healthcare directive? And this is one of those things where whenever I ask that in a life class, that I have usually 2/3 or more of the people in the class say they have one. So they probably pretty much know what it is. It's a relatively new thing in the big picture, because they've only been around since like 1985, but that's quite a bit now. Excuse me. On page 48 in the book, there is a healthcare quiz. And you can look through the healthcare quiz at your leisure. It's not something we're going to be talking about today. These books now officially belong to you. So you can write your name in the front cover. And other than page 51, you can scribble anywhere you want and make cartoon airplanes. I don't care. But on page 51, sometimes I like to have people hold off on that, maybe make a couple of copies if it's something that they really want to go through. Okay. Now, an advanced healthcare directive does some things that I was not aware. I was designated as somebody's healthcare agent. One of my best friends died in 2011. And I was the person appointed as her healthcare agent. And when we went to the funeral home, afterwards, I went with the family. I was not a family member. And I'm standing there in the funeral home with the family, and the funeral director says, who was the advanced healthcare agent? And I raised my hand. And from that moment on, he refused to talk to the family. He would only talk to me. And that's correct. So what did I do? I turned to the family and says, well, what do you want? Because it wasn't up to me. But he had to respect my authority simply because I was the advanced healthcare agent. And so an advanced healthcare directive is not just what happens to you before you die, it's your body, period. Okay? Now, it seems as though everybody should have one just for general principle, because I think it's a good idea. You can switch, next slide, please. Okay, a healthcare agent can act on your behalf when you are too ill to act for yourself or at the end of your life. And on page 51 is the quiz that I usually talk to people about. And it's semi-interesting, it's not, but it deals with very specific questions about you and how you're different. And I have always compared myself to my dad whenever I do things like this. So I will continue to do that. Now, the quiz can help you identify with a person. How to take a select healthcare agent quiz. Okay, create several copies. This is what I was saying before. And imagine you're a patient and take the quiz in private. The person who you want to designate as your healthcare agent, then have them take the quiz and then compare the answers and discuss the differences. Because what you really want is somebody who's willing to do what it is that you want done. And there are a multitude of different things. I usually tell a joke here, but I think I told this when I was down at you guys' place about the guy that walks into the bank and he pulls out a mask and a gun as soon as he gets through the door, and he covers his face and he walks up to the front, and there's a line of patrons waiting for the next clerk, and then there's the row of clerks. And just as he gets to the end of the customer line, his mask slips off. So he puts the mask back on, walks up to the first person in the teller line who was staring at him and says, "Sir, did you see my face?" And the guy nods yes, and he shoots him and he falls dead right there on the floor. And he looks at the lady behind him and says, "Ma'am, did you see my face?" And she says, "No, but my husband did." Okay. Well, I'm thinking maybe she's not the best person to act on his behalf as his healthcare agent. Okay, and another thing that you have to concern yourself with, if you have one child, if you're not married and you have one child, then the most logical person on the face of the planet for you to designate is that child. But you have to understand that what you're asking that child potentially to do is unplug mama. And so it's not something that all children can do. I have 3 kids. I know which one would unplug me yesterday. And I know which one would do basically what I want. And so that conversation has to take place. Okay, next slide, please. Okay, this is an example. And there's a couple of questions on here that we're not going to really get into. But again, like I said, I use my dad as my example because I was a co-caregiver for him for some years. He didn't really need much help, don't get me wrong. So I'm taking credit for having a cup of coffee with him in the morning and asking him how he is. But on one, it says circle a number for each answer that best represents how much you fear the following experiences when you are seriously ill or near the end of your life. And the example is being in pain, very little, some, very much. Okay, my dad had a threshold of pain. I mean, he might shake his head and go back to work if he got kicked in the head by a mule. I have to poke my finger every morning and I cry like a baby. So it's foolish because my level of pain tolerance isn't very high. My dad's level of pain tolerance was way up here. And so we are different. Everybody is different. So these are individual things for you to ask pertaining exclusively to how you feel about you. And then these are the answers that you compare with the person who you want to designate and explain what the differences are. Because they don't have to match up, but they should be able to explain what the differences are and understand each person's point of view. Next slide, please. Next slide, we don't have to do these. But all of these questions, and you can go ahead and skip through, all of these questions are in the book if you want to go through them. Okay, Advanced Healthcare Directives, next, there you go. Choosing the right persons, we sort of talked about. A lady, this is a story, because there used to be 2 presenters of this class. The guy that actually started this book, Scott Jones, who worked for the executive director of the courts in Ventura County. And he relayed a story about somebody that he knew who had designated their son-in-law, who was a doctor. And when it got right down to crunch time for her, and she was in the hospital and she required resuscitation, he resuscitated her, regardless of the fact that wasn't her wishes, because he felt he had to. He was a doctor. So it's important that you have those conversations with whoever you designate. And that's the whole purpose of this part of the presentation. Next slide, please. Now, there are several forms in the form that you can look at. On page 61 of the form, on the very top of the page, there is an actual example of the meats and potatoes of what the form is, that refers to check this box or initial this box, and then this is the level that you want. And in the event that the healthcare agent is not present, then the doctor has a reference point to say, okay, this is what I want done. And that can be very useful if it says what you want. And it's on that, you can take 30 seconds to read it, and then you can skip down and see that there are some empty lines. You can write in whatever you want, including, I want to go out kicking and screaming, plug me into everything, I don't want to go. If you want, because this is a personal thing. I had one lady say, I wrote in mine that I want full life support for 3 days, and then they can turn it off. And I thought about it and I said, sure, you can say whatever you want. I mean, this form is for you. But the more I thought about it, I thought, is this the Lazarus effect, or is there some biblical explanation? And I don't really know the answer, okay? On page 64, there are things that your healthcare agent must know. And that's what this book is for, is to go through and be able to explain in as nice a way as possible what your agent must know. And then on page 66, 8 good things a healthcare agent can do. And this is very informative, because the things that we're talking about is, and originally doctors hated this form. They did not want to deal this form. They did not want somebody telling them what to do over an unconscious patient. They were going to do whatever was right, not be dictated to by somebody else. But now they look at it exactly the opposite, because now they don't have to explain to everybody in the entire family exactly what's going on and answer everybody's questions. They are only obligated to explain it to one person, the healthcare agent, and then it's the healthcare agent's responsibility to spread that amongst the family. So it's a significant relief for most physicians under the circumstances. Okay. But also, you can set up medical treatment. So, and authorize specific medical treatment. So if you think something may be beneficial and this person needs it, but the doctors are reluctant to do it, hey, you get to say, you get to participate in the conversation. Okay. Next slide, please. Powers of attorney. Okay, one thing on advanced healthcare directives before I get to powers of attorney. Do you remember in conservatorships, you didn't know there was going to be a quiz, did you? In conservatorships, there were 2 elements, one of the person and one of the estate. If you have an advanced healthcare directive, then technically you have already personally designated who you want to be in charge under these circumstances. So do you absolutely need a conservatorship of the person, because you have already said, this is the person I want to do that? And most judges, depending on other factors, will say that's good enough. You don't need a conservatorship. Okay. Second branch to that is the power of attorney, because if you designate somebody as your agent under a power of attorney, then technically they have control of the estate part of the conservatorship. Now, originally, about the 12th century, when some lord wanted a piece of property somewhere else in the country, he got his squire, which would have been me, to write up a thing, and he would sign it and stamp it with his ring. And the squire went by ox cart to that other place and made the purchase on behalf of the Lord and purchased it in the Lord's name. Okay? Now, why would that be a problem? And the answer is because somebody else wanted it too. And they said, you can't do that. If you want to buy something, the law says you have to go and buy it. And it went all the way up through their court system, and at the top court said, well, why not? Why can't you send your squire up to do that in your name? Isn't that basically the same thing? But we're going to put two limitations on it. Limitation number one is you still have to be alive. And limitation number two is you still have to be conscious. So you can't be in a coma and have somebody buy a piece of property for you. The law will not allow that. Okay? Now, that worked pretty well until the 20th century, when and the reality of it is we don't use ox carts that often anymore. So it doesn't take 2 days to get from London to Newmarket. You do it in about 25 minutes. It's a pretty nice road. Okay? So now a 2-day trip anywhere, well, okay, I defy you to find a place on this entire planet that you can't get to in 24 hours, at least if you're willing to jump out of a perfectly good airplane with a parachute. Okay? Entire planet. And you can call, tweet, fax, Snapchat, and all of the other communication things. Zoom, perfectly good example, where you can communicate with virtually anybody on the planet instantaneously. So the requirements for the general power of attorney, for the most part, they're gone. They don't exist anymore. We have been made too convenient. Now, so what they did in the 60s was they did this, what they call a springing power. Next slide, please. Okay. But this is the definition of what a power of attorney is. A legal document that gives another person the authority to act as your legal representative and make legal and financial decisions on your behalf. You may decide that a person with a power of attorney can make decisions, sign your name to contracts, have legal power over your property or assets under the terms of the document. Okay? And you don't have to grant an umbrella of powers. You can grant a single power. If all you want them to do is to sell a property in Nebraska because you can't go, then it's a very limited power of attorney form. Okay? Next slide, please. Okay, I'm going to do springing powers here. A springing power of attorney is the ability for the power of attorney not to go away if you become incompetent. Because realistically, that's infinitely more important now than it has been in the past, simply because if you're in a coma for 10 years and if you want somebody to have the authority to deal with your problems, deal with your finances, then you can do a power of attorney with springing provisions, and the power of attorney does not become effective until you become incapacitated. And under the old law, it wouldn't occur, because as soon as you become incapacitated, the power of attorney ceases to exist. Now, if you die, it's still gone, okay? But a springing power on a power of attorney can be taken both ways, meaning that it doesn't have to spring into effect, that you can create a power of attorney and check the box that makes the power of attorney effective immediately when you sign it. It's effective immediately, and then isn't stopped by your subsequent incapacity. And most of the people that want powers of attorney nowadays, they really don't want their kids to have access to their bank accounts today. Just a little dangerous, but you may. And so it's really up to you. Now, understand that we get probably 2 phone calls a week from a parent complaining about something their kids did with their bank accounts. So we hesitate to tell people which to choose. We usually say, if you check this box, then the power of attorney only becomes effective once you become incapacitated. For most people, that's what they want. We're going back to what we talked about earlier, where this is not taking powers away like my dad lost his driver's license. This is sharing powers, because we get another phone call periodically that says, I gave my son power of attorney, now I can't get into my bank account anymore. That's not correct, because you're not giving away your authority with the power of attorney. You are simply sharing the power of attorney. Okay? Does that make sense? Hope so. But if you have a power of attorney and it says, when I become incapacitated, this power of so-and-so is appointed and designated as my power of attorney, then you probably don't need a conservatorship, because you have what would substitute for a conservatorship of the person and a conservatorship of the estate now with the power of attorney. So it's a sort of a practical solution, hopefully. Okay, next slide, please. Uh-oh, here we are. Now, again, this is another thing that the law has set up a spectrum. And way over here on this end of the spectrum, instead of Ozzie and Harriet or Mr. and Mrs. Cleaver, just a second. I can't see chat screen at all. Okay. Nobody's asking questions yet, so that's okay with me. That means I'm doing a good job. Oh, sorry. Or I'm not interesting, one of the two. First question that I'm going to ask here is, can you prepare your own will? Okay, so let's go down the spectrum here and say we got Bob the homeless guy pushing a Ralph's shopping cart with stuff in it that nobody on the face of the planet really wants except Bob. Okay, now, does he need a will? And the answer is not really, because he doesn't have anything. So he may need an advanced healthcare directive. He may need a power of attorney. I don't know. But he probably doesn't need a will, because he doesn't have anything that's ever going to be in dispute in the courts. Now, we move down the line this way to the guy that's got $10 million in the bank, but he has beneficiaries listed on those bank accounts. Does he need a will? And the answer is not really. Okay, because when he dies, the bank is already going to distribute his money. It's not going through a will. Even if he had a will that says, I give everything to Mike Williams, those bank accounts are going to whoever's listed as the beneficiary, because that's the contract the bank accepted when you named a beneficiary. Okay, so $10 million isn't a judge of whether or not you even need a will. Now, I'm going to take it a step further, because most people don't understand what happens if you don't have a will. And if you don't have a will, then the state of California wrote these horrible rules called the rules of intestate succession. Intestate, no will. Testate, will. Okay? For anybody that hadn't figured that out already. So the rules of intestate succession, somebody sat down in the 50s and said, if I died without a will, what would I want? And they made it the law. And people liked that so much that they called it the Uniform Probate Code, which has been adopted by probably 45 states, including the state of California. Now, we've doctored it, we've changed some stuff, and for the most part, for the better. So, but most people think, I'm still told at least once every couple of months that you have to have a will or the state of California is going to get it. And the answer is no. The only time the state of California ever gets it is, and it was the actual case would be called escheatment, which is a horrible word, but escheatment nonetheless. And what escheatment means is that there are no family members, not of first generation, second degree, third degree, fourth degree, no family members. Okay. Now, the only escheatment case that I was ever present in court to listen to was one of the most fascinating things I had ever heard, because the guy, this is probably, well, it's got to be, I was going to say 15, but it's got to be 25 years ago, because Judge Weller was still on the bench. And the case was called, and a lady stepped forward, and she was probably in her late 60s, and an attorney in the nicest suit I had ever seen on a man, okay, walked in, and the attorney addressed the judge, and the judge says, please help us explain what's going on. And he says, well, okay, this is a simple escheatment case, and we're claiming Mrs. X here is, Miss X is saying that she should be entitled to the property. And it was a ranch up in Ojai. And so I looked at a good friend of mine who later became a judge, and said, okay, this isn't going to work, because escheatment cases is pretty open and closed. You're related or you're not, okay? And so he went on to explain that this gentleman who died was a KGB agent, and he had defected from the Soviet Union, and he had not spoken with any of his friends for 2 years prior to when he defected. And she had defected with him, and they moved to Ojai, and he bought a spread and promised her that when he died, she'd get it. But the second half of the problem is that he had requested that she do something. So she had him cremated, snuck his ashes at great personal risk back into the Soviet Union, and buried his ashes at the gravesite of his parents, and then had gone to all of his friends and said he couldn't talk to you for 2 years before he defected because he didn't want you implicated. And then she snuck out of the country. Whoa, that's a pretty good story. And David, who was the guy sitting next to me, looked over at me and says, so who's going to play you when they make a movie out of this, right? And what did the judge do? And the answer is simple. The judge said, okay, you get the property. Because it wasn't just an oral promise. It was an oral promise attached to a request that seemed like a fairly interesting movie. So it turns out the state does not like escheatment cases because they get a lot of slack from it. People don't like it. Rumors keep blowing up. So what does happen if you die and you have family? And the answer is the rule of intestate succession. I think of this as a Christmas tree. And when I say a Christmas tree, everybody has this image of a pine tree. So I'm going to look at the bottom branch of the pine tree, and I'm going to say that hub is you and your spouse. And if both of you, if your spouse is alive, probably everything already belongs to her or him. Okay.
Alexa, what's the notification?
So if if there is no spouse, but you have children, then it simply goes down that branch to the children, and the children take it. That's the rules of intestate succession.
Alexa,
well, if you have no children and you're not married, then it goes up one branch to your parents. So if you're 17 years old, there's really no problem. You die, you have something, your parents get it. But if you're older and your parents are still alive, then they get it. But if they're deceased, then it goes to your siblings and down those branches. And if your siblings are deceased, then it goes to their children. And if you're an only child and your parents are deceased, then it goes up to the next, to your grandparents, and then down those branches to the aunts and uncles and the cousins, etc. And that's the progression, where you're going to be able to find somebody. There's going to be somebody in the family that still hangs around. Okay, that's how the rules of intestate succession would work. Now, I'm going to go back and look at myself, because I have 3 kids and a wife. And let's say that my wife is deceased, and so the rules of intestate succession would say that my children divide everything equally.
Unknown caller.
Well, I really don't want that. I really don't want it to be divided equally, because I pretty much gave one of my kids everything they're ever going to get from me. Okay? May sound evil. I don't care. It's the truth. And they can, the rules of intestate succession, they don't work so well for me. So if you want something other than the rules of intestate succession, then you pretty much have to have a will. Question number 1 here on this slide is, can you prepare a will? And the answer is yes, you can. It's called a holographic will, and you can handwrite it. And this is one of the few places where uniformly people take notes, because there's only 3 rules to writing your own holographic will. Okay? Rule number 1, it has to be in your own handwriting. Rule number 2, it has to be dated. And rule number 3, it has to be signed. Now, always I get a bundle of questions here, and most of them are, the answer is defer to rule 1. What does rule 1 say? Rule 1 says it has to be in your handwriting. So it can't be notarized. It can't be witnessed, because those aren't in your handwriting. Okay, now let's say that you have it witnessed. Judge is probably not going to throw it out, but it doesn't need to be witnessed. That's the whole point of this. You can sit in a hotel room in the middle of the night and write your will with nobody around, and that works just fine. Now, can it say property of Hilton Hotels up at the top? Judge is probably not going to give a hoot about that. But that a holographic will is perfectly fine. Now, having said that, I'm going to add a couple of other side rules. Okay? One is, try to do it on one piece of paper. And included in that rule is, if you, in the middle of the page, if your pen runs out of ink, start over. Use a brand new ink pen, use a different ink pen. Don't change pens in the middle of it, because now the date becomes in question. So don't create questions is the point to that. Now, the second rule that I'm going to attach is pretty straightforward. Write it like you're trying to explain what you want done to a 9-year-old. And I am not impinging the mental health of our judges. I'm trying to make sure you don't try to use legal words that you may or may not fully understand what they mean. And if you try to write it and it's crystal clear, like you would try to give instructions to a 9-year-old, you're probably good. Oh, question by Jan. There is no section in there on springing powers. My apologies. Let me drink a little water here while I got a second. Okay, good. Now, hiring an attorney to create a will, I think, is probably not a bad idea. It really depends on how complicated you want to do. If you can do it with a simple handwritten holographic will, I have nothing against that. If you want to leave out one of your children or give disproportionate distribution or give money to grandchildren or anybody else, then you pretty much need to consider working with an attorney, okay? Not mandatory. And we do, if you decide that you absolutely have to have a will yesterday and you want to sit down and write it out, we can figure out a way where I can look at the will, a copy of it, not the original, with your phone number written on the copy. And I would say, no, this is no good, or yes, this is okay. Okay, so that's something that we routinely do here at Gray Law. Okay, next slide, please. Okay, we kind of covered this, didn't we? Okay, you can skip forward, but that information is on page 67. Now, very popular nowadays is living trusts. And remember, we're talking about a spectrum where homeless Bob really doesn't need one, and the guy with $10,000 in the bank but beneficiaries on the account really doesn't even need a will. Okay, and now we've moved over here into where you can write your own will, and we've moved a little further, well, where you probably can't write your own will, but you may need, all you may need is a will. And then over here, we're talking about, all of a sudden, we're talking about living trusts. And living trusts are something that most people really genuinely do not understand how they work. So I'm going to spend some time explaining how a living trust works. Can you skip forward to the next slide to make sure I'm looking at the right one, because I don't remember. Can you prepare your own trust? There you go. Most people that own real estate in Southern California would benefit from a living trust. When completed, a living trust will own your home, not you. Well, wait a minute. So is that the dividing line of who might you be able to benefit from a trust? And the answer is, yeah, pretty much. Now, let's say that you have money in the banks and $10,000 in a CD with somebody else's name on it. You have a mobile home and you have a car. Is it going to go through probate? Because that's really the test. That's the question. Is my estate going to go through probate? And under those circumstances, the answer is no, because probate code section 13101 says, if your estate is less than $150,000, and I'm going to add something in that is actually from a different code section, and all your assets are less than $150,000, not counting a car or a mobile home, then it doesn't have to go through probate. It can be exempt from probate if you do it after a small estate declaration, which has to be signed in front of a notary. Okay, so if avoiding probate is the key, you have just successfully avoided probate simply because you don't own real estate. Now, I own real estate with my wife. So if I die, well, she already owns it. So it's not going through probate because she already owns it. Now, if I want to avoid probate when both of us are deceased, now we have to consider doing something like a living trust. Okay, and a proposition just passed, and I don't even know the full ramifications of it. Other than if your house is worth more than $1 million, it may be impacted. The capital gains tax basis and property taxes may be changed. So please, before you make any snap decisions, talk to a legal representative that is very familiar with the new propositions, which I'm not, okay? But ownership of property is kind of the key, the dividing line between who does need a living trust and who doesn't need a living trust. Because like I said, the gentleman that had $10 million, when he died, all of his money was in a bank account with beneficiaries listed. So there's beneficiaries listed. Does he need a will? He doesn't even need a will, much less the living trust. It's not going through probate. The bank is already going to pay that $10 million directly to whoever he lists, beneficiaries, children, girlfriend, doesn't matter. Whoever is listed on that, they get the money, which is the misconception by most parents, because they think, well, I've got 3 kids, so I'll put the one I want in charge on all the bank accounts. Well, but the legal result of that is they don't have to share. They don't have to share. It's just one of those things where it's no longer, the bank will simply issue a check to the name on of the beneficiary. That's it. So if you have 3 names on there, then they get 3 checks. You have 1 name on there, they get it with no obligation to distribute it, even if there's a will that says it has to be distributed. No obligation whatsoever, because that's not part of an estate. That passes outside of any probate code section, okay? Next slide, please. There you go. Now, this is a pretty simple graph. And here we have right in the middle, blue, where it says will. Okay, now, if you have an asset, all of the assets that you have in your name, that's an orange circle, are going to go into probate, unless they fall under probate code section 13101. If you have a will, it does not avoid probate. It just directs the probate and explains how the probate should be distributed, okay? So if you have a living trust, that's the yellow box, you transfer ownership of your assets. You literally do a deed to your home, so the piece of paper called your living trust owns the property. You don't own it. It's owned by that stack of papers. So you have to be careful, you have to pay attention. You are the trustor because you're creating your own trust. You're probably designating yourself as the trustee because as long as you're around, you want to be in charge of it. And then you name beneficiaries. And you would probably be considered the life beneficiary because you want any assets to inure to your benefit as long as you're alive. And then you have a successor trustee and remainder beneficiaries, okay? And the successor trustee, probably one of your kids, and the remainder beneficiaries, more than likely your kids. And that's how it works. And it avoids probate, not by magic act, but simply because you don't own the property. If you own the property, it's going through probate. So you diverse yourself of the property, and the successor trustee splits the property up. 2 forms required. One is called an affidavit death of trustee that has to be stapled to a certified copy of your death certificate. That's recorded in the county where your property is. And then a deed, a quitclaim deed generally. And the quitclaim deed would say from the successor trustee to the beneficiaries. And that's how property is transferred without having to go through probate. Okay, next slide, please. A trustor, that's you, if you're creating the trust, has 2 powers. Power number 1, to revoke the trust. Power number 2 is to amend the trust. The trustee, which is probably you, as long as you're around and competent, you would be similar to the president of a corporation. You're in charge of the day-to-day operations. That's what you do. Now, having said that, president is an interesting analogy because the closest legal analogy to a living trust is a corporation. You are creating a legally recognized entity that can own property. Now, most people, that's where they lose them, even though I've said it 3 or 4 times, the paper owns your property, okay? But nobody struggles with the concept of the Chrysler Corporation owning the Chrysler building in New York, although they don't anymore. But they did, and that was okay because they were allowed to in the corporate documents. The trust has the same type of power. It's a legally recognized entity. Okay, now, interestingly enough, it's based on your social security number. So as long as you're around, you don't have to go out and get a tax ID number like you would a corporation, and you don't have to slip into the corporate tax rates like a corporation might, okay? And that's really the distinction. But it is a legally recognized entity, and it has a significant authority over any property that it owns, okay? Oops. No, that's true. There's no living trust section in the book. The reason that I do this is specifically because one of the major areas where I get questions is because people want to know about their own living trusts. So that's why I have attached this as part of the class without including it in the book, okay? So my apologies for that. Next slide. Look what you have and decide and divide it into 4 basic food groups: real estate, assets with beneficiaries listed, tax-deferred assets, 401ks, etc. And tax-deferred asset almost universally have beneficiaries. So that should actually be included in the one above it. But I like to make sure that we talk 401ks, 357s, and all of those other tools that accountants and banks and retirement companies use. Because if you have named a beneficiary, then the impact is exactly the same. And then everything else. And if you have a $2 million couch, it probably has a title. I know for a fact that my couch does not have a title. My furniture does not have individual titles. My silverware doesn't have titles. My dishes don't have titles. So if somebody snuck into my house the second after I was dead and stole all of that stuff, then my kids probably could never prove it because it doesn't have any certificate of title. A bank account, a tax-deferred account, real estate, they all have titles. And so those are the assets that you're actually dealing with. If I do a probate for somebody, under normal circumstances, unless there's going to be a battle, under which case everything gets listed. If there's not going to be a battle, usually I tell the court the house is empty because nobody really wants to deal with the toaster oven. They just don't. And that's a truth. Okay, next slide, please. Attorneys do all kinds of different weird stuff. If a criminal law attorney, a corporate law attorney, a business law attorney may not be the right person to help you with a living trust, because that may not be part of the stuff that they do in their normal practice. It probably needs to be referred from somebody that you trust or like, but there's no problem with calling attorneys and saying, how much do you charge for a living trust? And it really depends on what their answer is. If they say $375 an hour, make another phone call. If they say $4,000, make another phone call. Make sure it's your best deal, because the price in Ventura County of a living trust routinely changes anywhere from $2,000 to probably $5,500 bucks. It's a big window. It's a big difference. Okay. Next box, please. Okay, now we're completely off topic. You thought that was off topic. There's nothing in the book about this. This is effective January 1st, 2017, which all of you guys have already qualified, okay, because you're still alive and it's 2020, putting up with this bizarre year. Now, effective January 1st, 2017, SB 833 became the law in the state of California. And they're actually trying to change a portion of this law as we speak, but it hasn't been. So this is still the law today. Medi-Cal payments made on your behalf do not have to be paid back if you are married at the time of your death and your wife gets the property, or you don't own the asset when you die. For example, a joint tenancy deed with your spouse or a living trust. If you don't own the property, then Medi-Cal doesn't get paid back, and the assets ultimately transfer to your children, which is what most people want. Now, I've had people say, well, that's horrible. The state has to be paid back. Well, okay, I can't argue with that. I'm just telling you what the law says, and what most of my clients don't want to be stripped of all of their finances because of being in a long-term care facility for 5 years and they die a pauper and their children don't get anything. Most of the clients that I deal with, that's not what they want. They want their children to get the bounty of what they have protected and what they have saved and what they have scrimped for in a lot of cases. Okay, so SB 833 did something. It's a little controversial depending on who you are, but at the same time, it's something that people need to know about. Next slide, please. Okay, now I'm going to get on a soapbox, and this is not going to take very long, but we've been here for an hour and a half, and I'm about ready to go get another glass of water. My soapbox is real simple, okay, because we are sort of in the county, the recognized as expert when it comes to dealing with clients on Medi-Cal. Okay, and dealing with clients on Medi-Cal is a very simple, straightforward concern because you don't qualify for Medi-Cal. Most of the people sitting here do not qualify for Medi-Cal. And the reason that they don't qualify for Medi-Cal, or you don't qualify for Medi-Cal, is because you have more assets than what is eligible to for Medi-Cal. The Medi-Cal limits are very simple. You can own a house, you can own a car, but everything else combined has to be less than $2,000. And so if you have money in the bank, boom, you're done. You're done anyway. And now the next thing is your income technically has to be less than $624 a month. Now there is an adjustment in California that brings it up to about $1,130 a month, but under normal circumstances, that's still less than what we get on our Social Security checks. And yes, I'm collecting Social Security. Now, having said that, under a special set of circumstances, you qualify under a different set of rules. And this is my soapbox, okay? Because if you're, and there's two questions. Question number one, are you married? And question number two, is your spouse in a skilled nursing facility? Okay? And if your spouse is in a skilled nursing facility or considering going into a skilled nursing facility, then this set of rules may be very important to you, okay? Because you get to keep a house and a car, but you also get to keep, my apologies, you also get to keep about $128,000 and income instead of $620 plus California adjustment, about $2,800 a month. This is the spouse that's not in the skilled nursing facility. So it's a different set of circumstances because what most, and the most horrible thing about this rule is its name, because the rule is totally cool, but the name of it is the Spousal Impoverishment Provisions of the Medicare Catastrophic Care Act. Now it seems, the title seems to be the opposite of what it's actually trying to do. It's trying to protect a spouse when your spouse has to go into a skilled nursing facility for whatever reason, and they charge $10,000 a month, that it will protect enough of a nest egg for the well spouse to make sure that they can survive. And that's the function of it. Now, there are lots of little side rules that apply. And I'm not going to go through this ad nauseum and try to explain all of those to you. The reason that I bring up my little soapbox is because most people are simply not aware that this may be something that could benefit them. And if not you, a family member, somebody in the parish, a neighbor, a distant relative. If somebody says, I don't know what I'm going to do, Bob's going to have to go into a skilled nursing facility, then all you need to do is remember that there may be a set of rules that specifically helps them. And you know that you can send them over to Graylaw and we can talk to them about it. And maybe there is something we can do for them. Okay. Graylaw has been around since June of 1979. And if you do the math, that's way too long. But that's okay. And this is what we do. We provide free legal information for senior citizens. But it's elder law we do. So if you rob a bank, call somebody else. If you want to get a divorce, call somebody else. If you want to sue somebody, call somebody else. But if you have a question about elder law, Social Security, public benefits, stuff like that, we may very well be the best place to get the first conversation going. Thank you guys for putting up with me for an hour and a half. And it was really weird not being able to see raised hands for questions. I just want you to know that. And I didn't hear a single person laugh at my joke, which is unnerving, but it didn't keep me from going on. Thank you guys very much for putting up with me again. I appreciate you guys all.
Thank you, Mike. We appreciate it.
Oh, my pleasure. Anything else? There weren't questions, so, but and if somebody has questions, it's a little complicated at Graylaw right now. We are technically not open most of the time. And since we've just gone purple, I don't know what they're going to require us to do. We are now effectively doing everything on the telephone. So call Graylaw, and our number is in the back of that book you just got. Same number.
Mike, I have a question. Okay, on the durable power of attorney, do you have to review it and revive it every so often?
No, unless it has a termination date.
Okay.
Now, the older advanced healthcare directives had two things. They had one expired in 7 years automatically, and the other one had a place where you could write a date in where it would expire. But okay. All of the modern ones, none of the modern ones do. None of them. So most of them go on ad nauseum, so to speak.
Okay. So we should look at the document that we have and go from there.
We have a boatload of power of attorney forms and advanced healthcare directives that we routinely give away for free. But you can download one off the internet. You don't have to call us. We'll give you one, no problem. But you can download one off the internet. I have seen at least 25 different advanced healthcare directives. And as far as I can tell, they're all good. As long as it's called advanced healthcare directive. If it says 5 wishes, I can't speak for that. If it says advanced healthcare directive, then I can speak for that. Okay.
Mike, how frequently should we go back and look at our living trust?
Oh, good question. I think you should periodically read it. Now, the reality, and annually at minimum, but the reality is there's normally only 2 places that really makes a difference. And that is who you designate as the next person in line as your successor trustee. Yeah. And the other one is who gets what.
Who gets
so what? If it says, if you have a question, you hate one of your kids now that you didn't hate 2 years ago. And I'm sorry, I get it all the time. I haven't spoken to them since I did this trust because they don't like the waffle iron going to Bob. Whatever. then you can change. I had a client who changed from one son to the other son and back again 14 times. That's called an amendment, and it cost her money every time she did it. Okay, but that was important. If it's important, fix it. If you look at it and it still says what you want, it's the question is, this is misleading from a lot of attorneys. If it was legal when it was executed,
I don't think so.
regardless of the changes in the law, it's still valid. Okay?
All right. Do you do amendments to trusts?
Not other people's trusts, no, because how can I say this without making a pitch? Because it's prohibitively expensive for me to amend somebody else's trust because I become responsible for that trust. And if I'm going to become responsible for the trust, I'm going to go through it with a fine-tooth comb. And that generally costs more than me just doing a new one.
Ah, okay.
Thank you, Mike.
Do you do new ones?
Yes.
Okay. How often should we have a new trust?
Never. You can do one every day for the rest of your life. But
No,
if
but
you
I
have
mean,
one that you're happy with, then why do another one?
If that, okay. All right.
Thank you,
that's
Mike.
My pleasure. Thank you guys very much.
well, thank you.
And I am checking out. Bye. Nice to see you all again.
Nice to see
well,
you.
Many of you. I have a picture of Yosemite that I like up there. I don't know who that is though. Anyway, thank you very much and good afternoon.
Okay.
Oops, there's the button.
Wrong
Bye-bye.
button. Okay. Hopefully, can you hear me?
Yes, yes, we can.
Okay. Hopefully everyone found something that was helpful to them. I know I certainly did. We appreciate his coming. I guess the next order of business, Teresa, unless you have something, the next order of business is talking about December, which we assume we will still be doing Zoom, and which means, of course, no wonderful Christmas banquet and all that entails. But we will try to, we're working on a meeting which will involve sharing. Who did I lose? We're working on a meeting which will involve sharing by different people traditional customs that they have for Christmas. I know Patricia is going to share about Las Posadas, and we're working on other ones. And I was hoping that as a part of the meeting, we can open it up during part of the time and have people who have different traditions that they have within their family that they think are special that they might like to share with the entire group. And then we will be looking for some Christmas music. Anyway, we'll do the best we can to make it a Christmas, a good Christmas meeting through Zoom. Okay.
Thank you, Jan.
Yeah, you're welcome. You're welcome. So, is there anything else that anyone would like to add or feel a need to share at this point? Okay. Teresa?
No, I think we're good.
I think we're good. Then I think that we will say goodbye until it's December 16th. Is that correct? Yeah, December 16th.
Thank you, Jan.
Yes, and please think about some special thing that you've done. I don't have any Christmas ones, but I do have a New Year's one that I will share. So anyway, thank you. So Teresa, I think we're done.
All righty.
Okay, and thank you for facilitating for us.
Absolutely.
You and Dawn. Okay.
All right. Take care, everybody. Bye-bye.